Well,
Hang on,
thank you.
let me
Thank you.
introduce you, Jeff.
Oh,
Hold on
yes.
one moment.
There we go. All right.
Welcome, everyone. My name is Cheryl Jones, and I'm here with Jeff Truman for our latest Baltimore County Bar Association webinar event. Jeff is a full-time independent mediator and arbitrator. He's experienced in a wide variety of litigated and non-litigated conflict resolution. He's a distinguished fellow of the International Academy of Mediators and an LLM candidate at the Strauss Institute for Dispute Resolution at the Pepperdine School of Law. Jeff is the past director of dispute resolution for the Civil Division of the Circuit Court for Baltimore City, and he's bringing a topic today that I think everyone should hear. So thank you, Jeff. I'm turning it over to you.
Well, okay. Thank you. Thank you very much for the invitation. I'm happy to be here and to present this topic because it expands the idea of what a mediator can do, really. I mean, I think we tend to default toward the role of a mediator who comes in after a dispute has erupted, usually in a litigated dispute, who comes in to try to resolve the case and settle the case, or do the very best you can and have the best conversation, generate the best look at the deal, the best deal that can be had at that time, and then make an informed decision. And if the case doesn't settle at that point, I consider that at least a successful process. But what that means is it's after the fact. And here we have an opportunity to talk about using those skills, okay? The staging a difficult conversation, the listening, the gathering of information, the communication, building some understanding and rapport, and perhaps even some trust, so that you avoid those kinds of protracted disputes. Because at the end of the day, you know, it's true whether it's a motor tort or med mal case or an estate related case, people try to predict the outcome. And, you know, it's escaped, I think, a lot of people that no one can predict the outcome of any of these things. You might have a certain percentage, you might have a certain feel, and you might be right. But the point is, here we can use the skills in a way that actually delivers a really good service to the client and helps them navigate and understand what the lay of the land is. It doesn't have to necessarily change their intentions, but it may. I think it gives options. And what it does is set the stage perhaps for a less contentious legacy. And that's promising. So let's talk about what that might mean. Let me share my screen, and there we go. So, and I'm going to, there we go. So as we know, this is a specialized field, okay? And it takes a lot of time and expertise to work with people really from any walk of life. So therefore, what tends to be ignored, no criticism intended, is the emotional and behavioral dynamics between the family members. It's just not on our screen. We're not trained for that. We may not be experienced in that. And culturally speaking, in addition to that, talking about end of life issues is never easy. It's not easy for anyone. I can understand that. But avoiding these issues is not a sound strategy, because it's like anything that's psychological and emotional. We may try to distract ourselves. We may try to deny ourselves, but it doesn't go away. And sometimes it can fester. Sometimes it can grow into an ugly outcome. And, you know, sometimes even with ourselves, if we don't take time for ourselves, we might snap at somebody and, God, what am I saying? What am I doing? And you start to realize, you know what, I just need some time either to recharge by virtue, or some people it's a introverted thing. I need time by myself, walk in the woods, meditate, exercise, whatever. Or extroverted, I just need to maybe see my family for a little while. Let's go have a vacation or have some fun to get away from the stresses, just to try to decompress. My point is that we need time in order to not let ourselves get into that place where resentment boils over into anger and ugly, bad choices. There are communication barriers that are kind of, you know, baked into these conversations, because end of life issues are just inherently tough to talk about. We don't really want to go there. We're not really that good, I would say, at really reflecting and being honest with ourselves when some tough choices need to be made. It's difficult to let go. Sometimes it's hard to let go of relationships. It may be hard to let go of a legacy of a lifetime of work and dedication. But I think if we can come at it from a place of understanding and a place of acceptance to try to walk through, and it might take more than a couple of attempts, by the way. These things just don't happen. You have to kind of be willing to break through over time and be patient. So much of this work is about patience. I don't care if you signed up for a half day, soft tissue motor tort case, or if it's something a lot more complex. The issues need time. You need time to walk through, develop rapport, and talk about the issues, but also talk about how to negotiate, how to listen, how to try to work through the issues, develop trust, think about timing. These are subtle. I would not call them soft skills, but I understand why some people might think of them as soft skills, but they are anything really, they're everything that matters in my world, in my opinion. These conversations are difficult. They feel taboo. It's understandable. The other practical side to this is that, look, not everybody has the same access to information. They don't have the same understanding, the same interest level, the same goals. So that can be a barrier for sure. I know certainly in my own life, I'm lucky to be married to a very creative artist, but I will tell you, she doesn't worry about the mail. Anything that has that looks official goes unopened. So she chose at least the right person in me, and in the sense that that's the first thing I look at. So we're a team in that regard, but that doesn't mean that she knows necessarily, what we could be doing in terms of a plan, a life estate plan, until we sit down and talk about it. And that's the key. And that brings me back to the dialogue and discussion and all of that management that needs to happen, just so that people can kind of get to that same place where they're able to make a plan and understand that that plan may have waves and affect other people. So how you can then talk about those waves and who they affect raises, of course, a conflict of interest issue. And that's where your mediator can really help you get the information that would be helpful, okay? Of course, let me just get on a soapbox just for a moment. And I think I'm probably preaching to the choir that, of course, without the work, without the efforts that go into prevention or better understanding, the only process you really then have is a litigated process. And of course, that has its limitations. It has a lot of risk, as we all know. Courts aren't necessarily concerned with finding what is a good solution for the family or for the people who are left behind. They're not necessarily solution focused at all. Judgments don't help people heal. They may not even be enforceable in some cases or collectible. And you have outsiders who have no idea, no appreciation. And that's set up by default, and that serves its purpose in society. But in these kinds of cases, that may really matter. They're not easy on relationships, as we all know. But when you're planning with a mediator, this is where I think the broadening, okay, the wider scope of understanding what the skill set is can really help. Think about a mediator, somebody who's more than just coming in to fix it later on. You can talk about what are the undercover interests that might be pushing someone's behavior, pushing their choices, pushing their rhetoric. What are the needs that are going on there? They're probably historical. There was a great therapist, and I'll admit it, I've been through my fair share of therapy, and it's a good thing because I learned a lot. And I think it's helped me become a much better mediator. And one of the sayings is that if it's hysterical, it's historical. And it makes a lot of sense. If your buttons are getting pushed on something and you're reacting in such a way that you may not understand, it has historical roots. And we were joking earlier about how so there's such a great wide wave of terrific parenting out there, not. And consequently, there's a lot of work, but there's a lot of mystery. So really, to get to it and not sound so critical, there's a lot of mystery as to why people behave the way they do. Well, they may not even know, but it goes back to what happened before. And you can't change the past, of course, but you can at least come to some measure of understanding. And like in any disputed case or any kind of high conflict person that you're working with, there's always a constant effort to try to keep us focused on the future. What can we do today? What can we do tomorrow? Can't change the past. We're going to have to work and learn how to manage it and live with it to some extent. And maybe the future can help incorporate and create a new narrative and create a new reality. And that, again, takes time. So that's why I emphasize these things do take time. And of course, that greater understanding and reduction of litigated possibilities can lead to a better outcome. Now, client may not be around to appreciate that, but certainly those who survive would. Yeah, there are some limitations, okay? As we were talking about earlier, whatever is discussed before someone's death may change. These are fluid dynamics, fluid situations. And so I don't know, I don't have an example where I can say that we built that in to a particular case, but I'm always open to that possibility. And maybe that's just my nature, is to try to just always be open for the possibility that, okay, can we incorporate the possibility of a change in circumstances into the language of what we're doing? I mean, maybe not, but it's worth talking about because it might assuage that concern to some extent. And I would just go back to the default of like saying, look, it's, mediation, one of the central pillars is about party determination, okay? And there's no difference here. So if you have very strong intentional designs and plans, I'm not looking to get in the way of that. I don't think any other mediator would be looking to get in the way of that. But it's to try to have a better sense of the circumstances, a better lay of the land in order to know how it's going to play out or to try to prevent the problems from happening in the first place. Maybe it's the conversation that's most important, not necessarily a particular agreement that gets reduced to writing. It might be just the conversation that's most important. Oftentimes when people are heard and they feel that they've been respected and that their views have been considered, even though there hasn't been a change in circumstances, that process can really be meaningful. And it can help people feel like, okay, we can still disagree, but I feel like you respected me and I feel like you heard me. And that goes a long way. It goes a long way in life. No different here. I'm just looking at my notes here. So as I was suggesting, the role of a mediator, think about it, I'd say conflict engagement advisor. That sounds very technical. Maybe a coach is a better way to put it. There are some terms of art that are thrown around, and conflict coaching is kind of a thing. I've never looked into it, and I'm not sure I know exactly what it may mean in that world, but I think of it as like you're helping, okay? You're there to try to advise. And along the way, as you know, if you've been in mediation, there are a lot of choices that need to be made along the way. Process choices, substantive choices, bargaining choices, all that stuff, choices as to who's going to be the neutral, who's going to be the mediator. And your presence there can help them navigate that. Most people haven't been through it. So those skills are portable, they're transportable. And this is where you can try to stage and have a conversation where we're getting real. Okay. I hate to say guidelines when I talk about conversations that are difficult, because I'm not so sure that people are always going to follow them, especially when it gets heated. People start to swear and they start to point their fingers, and they change from sort of I-centered language to more you-centered language. And that's never good, because that always usually creates defensive reactions, and then it sort of escalates from there. And that's not what we're looking to do, but maybe more like guidelines to say, what works at home tends to work here. Okay, you be respectful at home, you're respectful here. And whether home's the same place or it's a different place, I think people tend to get my drift. And you need somebody who's going to really be pretty strong about enforcing that sort of ethic to say, look, maybe we need to take a break. And you go into your separate rooms and you try to bring them back to reality and say, look, if you want to have a say, if you want to be heard, then you've got to reciprocate. And I think a lot of times people are willing to do that, especially if you can model it as the mediator. They'll start to pick up on it. And once the dynamic's there, you can start to get into some sensitive stuff, into some meaningful conversation without it exploding, especially when people start to use more self-centered I language. Well, this is how I feel whenever I hear that, or this is what I saw, or this is what I didn't see. It's hard to argue against that. But when, on the other hand, if they're saying, you did this, you did that, that's when people deny it and it becomes this whole thing. I think we all know that.
Yeah, Phil, can I ask a question?
Yeah.
I'm not sure how you get to the point where you get a mediator involved. In other words, if you get a call from a client, they want to have a will done, they may be married, have a with a wife or vice versa, have a husband, and they need wills. And typically, you would discuss with them the possible conflict that there would be in you representing both of them. Most of the time, they're willing to waive that. When there's prior marriage and children from a prior marriage, then it becomes a more serious matter, probably requiring another lawyer to represent the other spouse.
Right.
So then what I typically do is send out a financial questionnaire, and then based upon that and further discussion, as far as personal representative, trustee of a trust, this kind of stuff, then you begin to draft the will. So how, in that context, then, does mediation even become an issue?
It may not be. So the first answer I would have to say is that in a lot of cases, it's not an issue if people get along, if people are willing to waive any conflict and talk to you, or to maybe, let's say, if you have, I don't know, if you have one lawyer handling it, it may not be an issue at all. If, however, you have multiple marriages, and if there is some understanding that so-and-so is difficult, the eldest son, he's never gotten over XYZ, or the youngest sibling has never gotten over being youngest, that may be a sign. I think it would probably be a thread that you might notice and discuss when you're sitting at your office, for example, talking about this. I'm not sure it's going to come up when they fill out the forms that you send them. I think they're looking to give you that substantive information that you need regarding the assets and businesses and what their plans are. But the conversation is where I think it's more likely to come up, and you can probe and see what the real issues are, what they say. Like I said earlier, I'm not sure if you were on the platform, but they know the history, they know the issues, they know the people. And that would be something to really pay attention to, in my humble opinion, just to sort of make a note of and say, okay, if we need to bring in somebody to have a difficult conversation, because my clients are very clear about what their intentions are, and we expect that Junior is going to have a problem with that. And we don't really
isn't that up to the testator to, I assume the conversation has already taken place between the two spouses.
And that's why I'm saying, and you're right, and that's why I'm saying it may not be necessary at all.
Right. Okay.
But what I was saying earlier is that sometimes those conversations that you and I might think people are having, they're not having. Or yes, it's up to the testator. If the testator wants to go and talk to Junior about, look, this is what I'm going to do. Okay, I have a stage 4 diagnosis, and I'm sorry to say, but we got to have this conversation. Great. I analogize it to, look, if the parties resolve it directly, direct negotiations, and they don't need a neutral, a mediator, terrific. That's great. I'm glad you guys worked it out. But if that doesn't happen, here's a resource that's available to you. So that would be my answer. Sort of
in other words, if you're sensing there's some underlying issue that may result in a problem later, then bring that up and say, if this is an issue, then now might be the time to get somebody involved to try to resolve it before it becomes a matter of litigation later.
Yeah, how serious is the threat? How bad is the relationship? I would encourage, say, look, if you think there's going to be an issue, can you talk to them? I mean, maybe it's the other spouse who maybe has a good relationship. I mean, that's not always the case. Sometimes it's a worse relationship. and maybe the other spouse needs to be sort of away and not part of that discussion. So maybe there's just, I always think of it as certain conversation combinations, like who needs to talk to who, and when does that need to happen? How does that need to happen so that the best, most meaningful discussion can occur? It's sort of like setting the table for that. And
Could I jump in
Yeah.
for just one
Yeah.
second? Because recently I had a situation with a set of estate planning clients who had an estranged child. And during the course of developing their estate plan, we had conversation about what would happen once they passed away and they disinherited that child, and the likelihood of the litigation and the unhappiness that would ensue. And it was a great opportunity for me to encourage and send them all to mediation to try to iron out some of this. So to go circle back around to your question, Jim, sometimes it's developed, as Jeff said, in the conversations with the client when they are leaving out a child, treating children differently, cutting out a spouse to the extent that they can. And in my situation, it was actually very fruitful for the parents and the child to be able to hash out some of their current issues before mom and dad finished their estate planning, so that we could hope to avoid a caveat or, a will contest down the road.
Was the estrangement resolved?
Not entirely, but at least some of the issues got brought to the table and could be resolved. And at least the relationship was moving in a forward direction where it had simply stopped prior to. So
I'm not surprised. I mean, again, it's not like, and I just have to use this analogy because I think it makes the point. It's not like just there's going to be some concession, like the payment of money to resolve a dispute. This is a family, organic thing that's grown over the course of a generation, and the best sometimes you can hope for is provisional, sort of temporary timeframes to sort of try to live with it, maybe check back in 6 months. I mean, I've certainly done that in a ton of guardianship cases where we did temporary sort of deals to sort of see how the new set of terms would work for a little while. It raises sort of, it's time. Your question's wonderfully timed because this is the next slide. And I say, it's a partial list because, Cheryl's talking about the estranged child. That certainly should be on there. And, anytime a family member brings it up in your conversation is something, again, to take note of. We touched on a couple of these, Brittany, earlier when we were talking. So I don't know if I need to read them to you, but anytime there's multiple marriages, that certainly to me is a red flag, because there's always that, there's a lot of understandable connection to the bloodline. I mean, we see that in the law for sure, but it's certainly alive and true in my family. And I know it's created some talking points. Let me be the diplomat here, between my wife and my family. So it's real. And again, I've seen it also where a child comes in and cares for mom or dad when they have dementia, Parkinson's, what have you, and they just can't care for themselves and they don't want to go into an extended care facility. So it creates a lot of expectations. So that's just a partial list. I think when to really take note of what it could happen. I'll talk about, again, sort of my soapbox a little bit. These are really important issues, in my opinion. I would not dismiss them as touchy-feely by any means. Perhaps I'm preaching to the choir again, but I just felt the need to sort of just say that because emotions affect how we make choices. And I think there was some study where there was a terrible accident, an industrial accident, where somebody was brain damaged and they were freed, I guess, from any of their emotional expression, and they couldn't make decisions. And there's a whole world of behavioral economics that's out there that we talk about as mediators all the time, because they affect how we value things, how we respond to loss, or perceived loss or risk of loss. And those are emotional heuristics. In other words, they're brain shortcuts that hijack our thinking. And we don't even realize it. And we're all subject to it. There's some wonderful books you can get, Predictably Irrational, Dan Ariely. That's a wonderful book. It's similar to Thinking Fast and Slow. That's a harder, more technical read. But there's another book about those authors, and I think it's called The Invisible Project, it might be, but Daniel Kahneman, spelled with a K. If you look up his name, you'll see the related books that he's done and the studies that he's done. And it's to sort of debunk this idea that we are rational when it comes to managing uncertainty, especially around money and things of value. It's a very interesting field, and it's I don't want to add to your work, but it is relevant. So I would just say that. You know, and I've touched on this earlier, parents still retain control of the planning process. This discussion can reduce the chances of conflict down the road. You know, they don't have to disclose everything about their estate. I know that can be a sensitive issue, but it may be about expectations without getting into the details. So that's a conversation that the mediator should have preliminarily before jumping into the fray, to sort of see what's in bounds, what's out of bounds, what's to be disclosed, what's not to be disclosed. There's the other point that I think is really important, is that it sets the precedence for dialogue. So rather than just run to the courthouse, which is what people do when they don't talk, here's an opportunity to show a more constructive, productive way of handling these issues. I think of it as a mini sort of step clause. Let's have a discussion first, a direct discussion, without the need of any other professional to help us. And if we can't make progress or come to some manageable understanding for a time, then we'll try to get somebody to help us. And then if that's still not viable, then we may have to go the route where we all lose control over the outcome, but we get somebody as a decider, God forbid, to make that decision. Then of course we either may be stuck with it, or we may get caught up in, you know, a long-winded process of unwinding it or enforcing it or dealing with it. And that last point I touched on earlier, that's what I call durability. When it comes to family businesses, there's a lot to talk about, of course. You know, what does the future look like for the business? Who owns what? You know, what are the shares? How are they valued? How are they transferred? You know, who's really going to be in the management position? And how will decisions be made? Are there other people involved? How big is the business? How will disagreements be managed? You know, board of directors might be a really good idea if you have a contentious set of siblings, let's say, who are involved. You know, again, it's sort of talking to two brothers next week about their business. They've been doing really well, but they're not getting along, and they're talking about litigation. So, you know, I don't know anything about it right now, but I do know that my questions are going to be, so who else is involved? Who else do I need to talk to? Have you built in these kinds of systems? And I'm going to address that more specifically here. You know, over time, you have somebody that founded the business. They're used to calling the shots, living with it 24/7. They've been successful. But as time goes on, you know, it starts to disperse and become a little bit more diffuse, because you have shares that are, like, say, within the family, and then you might have outsiders. I call, you know, at least they may be cousins or other relatives, but even perhaps non-family members who take on very important roles. And that's just how it tends to go. So I start to think about, well, do we need a system of sorts to be implemented? Because no one's thought about that, perhaps. Instead of approaching, again, an HR issue or a brothers who are fighting over the business and how it should be managed and led, that's not necessarily a one-off problem, right? It could be more about what systems aren't there in terms of governance and management. It could be about access to information. It could be about financial management. Who else is involved? Do you have outsiders who can keep people honest? I say that in quotes to the outsider. Sometimes that's what you need. Usually it does happen on that left side here: personnel, hiring, firing, financial management, control. Again, I think of it more as a process, not necessarily as a one-off. I think these are common. They seem common on the outside, like now when we're talking about this, because we're removed from the actual thing. But when things evolve in such a way, you don't always think that you need an HR policy or that you necessarily need these types of systems until something happens, and then you're hit with it. So again, I just use that analogy from construction where you have step clauses. Let's talk first. If we can't talk, we'll get somebody to help us to talk. If that doesn't work, we'll give the keys to somebody else. Deadlines are a wonderful tool in dispute resolution. I'm a big fan of them because they can always be reset, or usually be reset. But I think they've helped people take things seriously. Certainly when I was with the circuit court, whenever trial dates kept getting pushed out further and further and further, the parties they didn't really get real until, the eve of trial, despite the obvious inefficiencies in that. It tends to happen. Again, as I mentioned earlier, perhaps non-family members in some advisory capacity would be helpful. I think who needs to be a part of which meetings and when, and access to which information can also be really critical. Overall, this just leads to better outcomes and reduces the potential for malpractice claims, of course, which is always a good thing. But it really, yeah. So I say that a bit tongue in cheek, but I also say it a bit serious too. But the most important thing is that it helps your clients get their intentions to be realized, and without it being diluted by some infighting. I know most parents don't want to see that happen, even from above the clouds or below the ground or wherever they are. So that's kind of what I have. I know I'm ending a little bit early, but let's have a conversation if there are issues or other experiences that you guys have had where this has worked or hasn't worked, or maybe where it might work. Feel free.
I think the family business part makes a lot of sense, because then you have a tie-in with the person sitting in front of you who may be the owner of the business. And obviously all those other factors that you were talking about can come into play. So that seems quite logical to me.
There's a lot at stake.
I don't see it in the run-of-the-mill circumstance that I run into.
Yeah, I bet you're right. Because, I mean, look, there's just not a lot there to really catch people.
Right.
But if they've been involved in the business and it's been successful, it's just a lot more to think about. In my opinion, the legacy has more meaning, because it's like, my dad built this, we did it or my grandfather built this, and there's talk about identity. I mean, it's a really powerful thing, and it's hard to imagine, sort of being squeezed out of something.
Let me ask you this. So you make the suggestion to the client, and then the client begins conversation with the folks involved, his children or whoever. Can that in turn create more of a problem than you had to begin with? In other words, then then everybody ends up hating each other.
I think that's always a risk. I suppose I don't know which bad outcome is worse, ignoring it or trying to manage it. I think if you get somebody that is willing to say, look, we may not have all the answers, but we're here in an effort to try to work together. There's a lot to be said for setting up the process in a way that engenders some willingness to participate. I mean, you have to build in an understanding that, look, reciprocal positive behavior is contagious. And so you don't have to have the answers, but you have to have that process and some measure of trust over time and some understanding that we're all working together here in order to have something good come out of it and avoid that bad outcome. I think if it's mismanaged, clearly that can lead to damage, but it doesn't have to. I mean, it's the same possibility, for example, when you have a guardianship or you have any other, I don't know, litigated case where, you know, people are offended, you know, because the offers are too paltry or the demands are too ridiculous or so-and-so is being arrogant. And I mean, isn't that the same set of risks you have really in any kind of dispute?
Yeah, but I mean, when the client's sitting there, I mean, I think a lot of people would feel like, well, you know, if we raise this now and get them all involved, we're going to open a can of worms that we never be able to close. Whereas if we're just sitting here, you know, two spouses making the decisions, you know, we'll be dead if there is a dispute, so we don't have to worry about it.
I know, and that I suppose factually is true, but they don't want their legacy to be, I guess, hijacked. I don't think anybody really wants their legacy to be hijacked by a conflict that at least could have been addressed. I mean, I don't want to oversell it by any means, because sometimes these conversations don't work because the conflict is so bad, it's so toxic. It's, you know, it's probably best that they go their separate ways if they can and work it out with a payment or whatever it is, and people go on their separate ways. I mean, I've had that, and that's the way it had to go. On the other hand, I don't really know that. You know, sometimes it's like you get into it and you can steer it away. I mean, I've had cases where people said to me, wait till you meet the daughter, just wait. And yeah, it was difficult at first until you give her an opportunity to be heard. You react in a way, I should say respond in a way that asks for more information. Please share with me what's going on. And what starts out as a defensive posture where she's not even sitting down. She's sitting down, she's talking, and I'm asking questions, and all of a sudden you see her shoulders slump and she starts to cry about she just wants the very best for her dad, because he took care of her at a time when she was vulnerable, and she didn't, now that he's vulnerable, want to put him away. And was that, you know what I mean? It sounds simple, but it took a long time to get there. And it's with that level of defense going up, clearly no one else had that conversation. I understand no one really, it wasn't their job. I'm not criticizing it, but it just hadn't happened. Okay. So, and I'm not saying that I'm the only one who can do this. I'm just saying that there are people who can help with that conversation. And sure, there's always a risk that it could go bad, but I don't think that's a reason to necessarily avoid it. And I think maybe, again, going back to what you were saying earlier, what we were saying, if you can have that conversation directly, go for it. You don't have to hire somebody to help you do that. If you guys can do it on your own. Or if you think there might be some sort of ruffled feathers, but it's not going to erupt in litigation, then fine. Then fine. I mean, sometimes people's nose get bent out of shape, but it doesn't mean they're going to sue.
Right. All right. Well, listen, I appreciate it, Jeff. You give me something to think about. I've got to sign off.
No problem.
Thank you very
I appreciate
much.
the questions.
Thanks,
Appreciate the
everybody.
questions.
Bye-bye.
Thank you.
So thank
You know,
you for
with-
the opportunity.
Can you all hear me? I'm not sure. I can't. I don't have my picture up on the screen, but this is AJ Serbicki. I have found that with small businesses, whether it's family members or just individuals, you know, at the outset, when I'm forming this entity, you know, just bring up the idea of a buy-sell agreement, which in many ways addresses a lot of the issues. Like you mentioned earlier that, you know, you're going to meet with two brothers next week and they're having problems. Well, in some instances, a buy-sell agreement, when things are just beginning and the future's rosy, you can address a lot of these issues because at that point, they're all simply theoretical. And I just find that really helpful to have with business entities a buy-sell agreement that will talk about a lot, well, what will be the share price if people, if things don't go according to plan, or somebody dies, or someone's disabled, or someone wants to sell their shares. And you can make a lot of provisions that will mechanically address some of these problems, because where you are with meeting these people, the cat's out of the bag, if you will. And it's much more difficult. But a buy-sell agreement, I find at the jump with the business clients really helps.
I totally agree. I think that is a terrific way to encompass, because it's a contract and you can put these provisions that address in a systemic way everything we've talked about. So I totally agree with you. My only bit would be to say, and it still has to be negotiated, right? I mean, that.
Right, exactly.
Yeah,
But
so,
at least at that point, they don't hate one another,
Well,
So
and that's a
good
timing issue. That's a timing issue. And I agree with you. I mean, certainly the earlier, the better. And if that means you forestall a lot of the headaches and the heartaches, sure, that's terrific. And it might be a great way to sort of get it done in an encompassing way earlier on. So yeah, if the timing works out, all the better. Yep.
Yeah.
Yep. Anything else? What do you think, Cheryl?
It's great. Can you give me a ballpark of what the costs involved in a mediation? Are they generally hourly charges?
Usually, but I mean, I've adjusted my fees. For example, if I know that it's not a litigated case, then I'm going to, because people don't really want to think that you're hiring somebody, at a pretty good rate without some idea about what's it really going to cost me. I don't want to sign up for something that's going to bleed me. So,
right.
And I get that. And I would feel the same way. So I've said to them, look, here's what I'd like to do. I'm going to meet with you, and I might want to meet with your dad, and maybe we have a joint conversation. Maybe we don't. But at least at that point, I will have some sense as to what maybe we do in terms of like stage 2. So I'm going to estimate it as, I don't know, 6 hours, 8 hours, whatever. And I'll cap it to say, at least at sort of like, stage 1, you're not going to spend more than X. Okay.
Got it.
And then, at that point, what I hope to deliver for you is some ideas about how we can resolve this. And, to AJ's point, maybe it is a buy sell. And even if it's late in the game, it's a framework that everyone can kind of start thinking about how this is going to exit, how this is going to resolve, how that guy's going to finally leave. So, it's got to be something like that in a family business situation. I mean, without that, it might be just a session. If it's a regular old mediation, I might think of it as, well, it's either a day or half a day. Well, let's just say, and, I will maybe include an hour or 2 of prep work. And that's almost always reaching out to the parties and or the lawyers ahead of time. I always, whenever my schedule allows, I want to hit the deck running. So I know I don't want to start learning that stuff. I want to have thought about it, come to the table with a strategy so that I can direct us in the most efficient way that I can. Now, granted, stuff may still happen and we're just going to have to deal with it. And if we go over, we go over. No big deal. I'm not going to charge them for that.
Well, this has been helpful, at least for me, because as I told you, I literally had this case, this happen where we brought in mediation in a recent estate planning matter, and it was eye-opening to sort of see how it could be used. Sort of atypical in an estate planning case, but it may be time for us to start integrating it in when it's appropriate to do so.
It's a tool, right? It's a tool in the right set of circumstances. It's like a toolbox. It's like, when you have the right problem that comes along, you might have the tool for it and see how it goes, but at least know that it's flexible and know that it's, and it may be targeted. It may be just for a very limited purpose because of the circumstances that you're in. And that's okay. It's no different than any other sort of, narrow mediation where it's like, look, I only want you to come in for a few hours. If we can't get it done there, then we're probably, and it's like, okay, I got it. Message received. We don't have to make it more complicated than you guys think it is, because you guys have been living with it, whereas I have not been.
Yep. Okay.
So, Cool. Well, thank you again for the opportunity. I really do appreciate it, and look forward to spring and a time when we can be out in social and having fun.
Absolutely. Thank you so much, Jeff. Britt, do we have any business after the fact?
No, we are good to go. Thank you again, Jeff. And thank you, Cheryl, so much for arranging this. This is wonderful.
Absolutely. Thanks, Jeff. Have a great evening.
You bet.
Thank you. Thank you very
Thanks.
much.
Thank you, everybody.
Okay.
Bye-bye, Rachel.
Bye-bye. I'm going to go ahead and log off, and I figure you guys can cut the recording and edit it or whatever. So
We will
thanks
edit
again.
everything.
Yeah.
Thank you
Thanks
so
again
much.
for the
Thank you.
opportunity.
Jeff, appreciate it.
Bye-bye.
Yep. Take
Bye.
care.
Good night.